Hello children, welcome you all for the second session, and the topic which we are dealing today is deemed owners, and the chapter is income from house property. In the previous session we were talking about and we have discussed about the basis of charge and also ownership of house property. In this session we will be moving on towards the topic deemed owners. What is deemed owners? As specified under section 27 of the Income Tax Act, in certain circumstances, persons who are not legal owners are to be treated as deemed owners of the house property for the purpose of tax liability under this head. It only means that in certain circumstances, the circumstances will be discussed further. But what we have to understand here is that there are certain circumstances wherein a person is not the legal owner, but still he will be treated as the deemed owner of the house, and the income that he receives from that house property will be taxable under this head, and it will be treated as a tax liability. As mentioned in the slide, point number A and B, I am clubbing both the points and explaining you that as to who is considered as a deemed owner. If any individual transfers a house property to his or her spouse or to the minor child without adequate consideration, he is deemed as the owner of the property for the tax purposes. What happens here is that whenever you are transferring the property, there is expectation of a consideration. That means, what is consideration? Something which you get in return is called as consideration. So if any individual is transferring the house property to his or her spouse or to the minor child without adequate consideration, there is no consideration, and the consideration in certain situation is not adequate. In this situation, he is deemed as the owner of the property to the tax purposes. So when you are not receiving any consideration, when you are not receiving any adequate consideration, and you have transferred the property to your spouse or to the minor child, then you yourself will be treated as a deemed owner of the property for the tax purposes, and you are eligible to pay the tax. So as told by me, the first and the second point is being clubbed by me. Coming to the third point, the holder of an impartial estate is deemed to be the owner of all the properties comprised in the estate. So you are not holding the entire estate here, but you are holder of an impartial estate. So in such situation, you are eligible and you will be called as a deemed owner, and you are assessed to tax under the head income from house property. Coming to the fourth point. The fourth point states that when a member of a cooperative society, company or association of persons to whom a property is allotted or leased under the house building scheme of the society, company or association is deemed to be the owner of such property. What this point means is that if you are a member of a cooperative society, or if you are a member of a company, or if you are a member of any other association, and if you are being allotted a house property by virtue of being a member, even though the property is registered in the name of the society, company or association, you are regarded as a deemed owner, and you will be assessed to tax under the head income from house property. Coming to the next point. If a person who has acquired a property under the power of attorney transaction by satisfying the conditions of section 53A of the Transfer of Property Act, that is under a written agreement, the purchaser has paid the consideration or is ready to pay the consideration and has taken the possession of the property, is a deemed owner of the property, although he may not be the registered owner. So this is what, when the property has been transferred, to the individual's name as part performance of the contract under section 53 of the Transfer of Property Act of 1882. But the title deeds have not yet been transferred, but still you are regarded as a deemed owner and you are assessed to tax under the head income from house property. Next is, it is actually an addition to the previous point. Coming to the next point now, when the property has been constructed on a leasehold land. Whenever you are constructing the property on the leasehold land, so the person who is holding that particular property will be regarded as a deemed owner and he is supposed to pay the tax under the head income from house property. Whenever there is any property where the ownership of the property is under dispute or it is under litigation, but you are owning that particular property, so you will be treated as the deemed owner of that particular property and you will be assessed to tax. Next you have the next point is, when the property is taken on a lease for a period of not less than 12 years, then the lessee shall be deemed as a owner of the property. So in these circumstances also, the holder of the lease agreement will be regarded as a deemed owner. I repeat the point, where the property is taken on a lease for a period of not less than 12 years, then the lessee shall be deemed as a owner of the property. So by